the help of the industrial designs. Any important information, any secret of any company is protected with the help of the trade secrets. The IC circuit, integrated circuits of computers are protected through layout design. The new varieties of plants are protected with the help of plant varieties, and the heritage of our country is protected through the geographical indications. So there are various kinds of intellect, and these are protected with different form of the IPRs. So patent is the one form of the IPR, intellectual property rights. Now we will discuss about patent in details. For example, this is a simple product, a pen. This is protected through the multiple type of the IPRs. So all the products in the market are usually protected through the various kinds of the IPRs. So what is the patent? Patent is an intellectual property right. These rights are granted to the owner or patentee for a new product or new process by the government, and this allows the owner to have the exclusive rights to manufacture, sale, or use of that patent for a limited span of time. Usually in countries, in India and in other countries, this span time is the 20 years. So patent is related to the invention, protection of an invention. So this protection of invention is come in the form of the patent. The government give us right to use that patent for 20 years. So we have all right on the patent. We can sell it, we can gift it, we can use it, and we can without the consent of a patentee, no one can use it. So patent is if there is a problem and you have a solution of that problem, and this is the invention. So as I already discussed, this is for a 20 years, and there is no such term like global patents, because the patents are all territorial rights. If you want to protect your product in India, then if your patent is India, then only Indian government give you right of that patent. If you want to protect your product in other countries, then you have to file the patent in that countries. So there is no one country which gives you worldwide protection. These are all territorial, just like the real estate property. So what is invention? According to the Patent Act Section 2(1)(j), invention means any new product or new process which have basically three criteria: which is new, which is novel. Novel means it should not be known anywhere in the world. It should be novel. And second, it should have some inventive step. Inventive step means it should not be obvious to a person who is skilled in the art. For example, there is a table with four legs, and it is very obvious for a carpenter to make a table with 5 or 6 legs. So not obvious to a person who is skilled in art, but your work should not be obvious to a person who is skilled in this art. This is very important aspect of any patent. And secondly, your work should have some technical advancement, or it should have some economical significance, or both. And third is your work should have some industrial application, should have some use. So these are the three main parameters of any patent. It should be novel, it should have inventiveness, and it should have some industrial applicability. For example, your work has feature A, B, C, and D, and there is a document which having all the A, B, C, and D features. Then your work will not be considered as novel. Similarly, if there are two documents, one document covers the feature A, B, D, and second document covers the feature C. So if we combine the knowledge of these two documents, then your work will may be considered as obvious. So this will hamper the inventiveness of your work. So your work will not be considered as patentable. So there are various subject matters which are patentable and which are not patentable. What we can patent? We can patent a new product, a new process, or a new product by a new process, or living subject matters like microorganisms. So any new product, any new process, product by process, and microorganisms are patentable according to Indian Patent Act. And what are not patentable? There are many things which are not patentable. Firstly, anything which is frivolous, anything which is contrary to well-established natural law is not patentable. Anything that is injurious to health, injurious to public is not patentable. Any abstract theory, scientific principle is not patentable. New use or property of already existing substances or drugs is not patentable. Mere admixture mere admixture of two things is or more than two things is not patentable. Mere arrangement or rearrangement of the things or devices is not patentable. Method of agriculture and horticulture is not patentable. The method of treatment of human beings, animals are not patentable. Diagnostic methods are not patentable. But if you make a device, any diagnostic device or therapeutic device, that you can have a patent on that. But the method of treatment is not patentable. Plants and animals as wholes and microorganisms. Plants and animals are not patentable, but microorganisms are patentable. Any biological process is not patentable. Mathematical and business models, computer programs, these are not patentable. Any literary, dramatical, artistic work is not patentable because these are protected through the copyrights. Any method of playing games, presentations, these are not patentables. Invention related to atomic energies are not patentable, but here are some exemptions in this. So we get the patent even of related to radiopharmaceuticals. So last, any traditional knowledge are not patentable. So here are some interesting patents like electric bulb, the mechanism to open a can, and needles, simple paper clips. So these are all in patents on because they provide solution of some problem. So why it is important to protect an idea? So if you don't protect your work, then anyone can copy it, anyone can use it, and even other can protect it at their own name. So it is better to protect your work. Secondly, if you are in industry, if you are in commercialization, then it is helps you to growing faster. If you can even license your patent to any company, and you can get the royalty or money from that. Thirdly, for business perspective, it is point of view, it is very important to have a patent because all the industries, either pharma, any of any field industries, they have very good IPR portfolios, and the technology is the very important aspect to grow and sustain in the market. So next, who can apply for a patent? Any individual, natural person can apply for a patent. Educational institutes can apply for a patent. Startups, small entities, any legal entity, company, corporates can be applied for a patent. So what is the right time to apply for a patent? So firstly, if you have an idea, but your work is not completed or you have half done work, then you can go with the provisional filing. So firstly, if you have an idea, firstly what you can do the patentability search. Patentability search means your work is patentable or not. So there are three criteria, as I already discussed about the patent. So these three criteria should be fulfilled for for any patent. So firstly, go for the patentability search. So if your work is seems as patentable, then you can go with the provisional specification. So after provisional specification, we usually give the title and a field with in which field your work belongs to. Thirdly, a brief idea, a brief introduction about your work. But in provisional specification, no claims are provided and no details description are provided. After filing the provisional specification within 12 months, you have to file the complete specification, which includes the claims as well as detailed description. If your work is not completed within 12 months, then you can post date your application for maximum of 6 months. For example, you file your patent application on 1st June 2022. So according to Act, you have to file your complete specification up to 1st June 2023. But if your work is not completed, then you can post date it for maximum up to 6 months. So by this, your date of filing will be shifted according to your choice. So you can post it according to your choice. Ki how many days you want to be posted it for 1 month, 2 months, or maximum it can be posted to 6 months. So if you have all the complete data, you can directly go with the complete specification after doing the patentability search. Now, how to do the patentability search? You can do it by own, or you can take the help of any expert. So for if you want to do the patentability search by own, there various patent databases are available. For example, free databases, these are very good databases. You can take the help of these. For example, in past, this is Indian IP database. Second is the eSpaceNet. This is the European database. And Patent Scope, this is the worldwide WIPO database, and Google Patents. So these are the free database. You can take the help of these uh, for checking the patentability search of your work. Or you can take the help of the experts, patent agent, IPR firms to make a report of patentability search. They have some paid databases. So it's all upon your choices. So once you file the patent application, then you are safe to discuss about it, or even you can publish your work in any journal. So how to apply for a patent? So, so after taking the institution approval, you can directly go with the patent agent or attorney, or maybe your institution have tie up with the PIC, Patent Information. These are the centers established by the government, TIFAC New Delhi. So they have their own channel to file a patent. So here the PIC route is free of cost. The all the expenses are bear by the Delhi, TIFAC Delhi, and here the expenses are bear by the applicant. But in this case, the process is lengthy, approximately 3-4 years. At least 3-4 years taken to grant a patent, but here we can do the things on priority basis and can file the patent even within a year. So what is the patent process, filing and grant process in India? So firstly, after the conceptualization of idea and patentability search, now there are two type of filing of patent. As I already discussed, complete specification and provisional specification. The further provisional specification, within 12 months we have to submit the complete specification. Otherwise, the application will be abandoned. So if when we file the complete specification, then it will be get published by the patent office after the 18 months from the date of filing. So this is the cover page of the Journal of Indian Patent Office. Also, after publishing the patent application, the patent office examine the application when we request them to examine our application. So within 48 months, within 4 years, we can request the patent office to examine our application. So patent office examine our application and they issued the first examination report, in which they cite some documents related to our work, that our work is novel or inventive in respect of that documents or not. So they give the all details about our work. Either they have three type: novelty, yes or no; industrial applicability, yes or no; no inventiveness, yes or no; there any objection also. They give all the details about our work in the FPR. So we have to file the reply of FPR within the 6 months of issue date of FPR. So if all the objections are met within 12 months, then the patent is granted. If they have still have an objection, then they give us chance the hearing in hearing there is one-to-one meeting with the controller of examination as well as the patent agent and the applicant. So there we discuss all the points, and we try to convince the controller about the about the patentability of work, and if there are any modifications are required to do in the application, then the controller give us all the opinions. So if all after all the things, if the controller gets satisfied, then the patent is granted, and if the controller is not satisfied, then the patent is not granted. So this is the whole process of patenting in India. So what is the fee structure? So for filing of patent application, for individual, for natural person, or for educational institute, this is the 1600 rupees. And for request for examination, this is the 4000 rupees. So this is the normal mode of filing of patent or examination of patent in India. But there is another mode. This is known as the expedite examination. In this, the whole process is get faster. So, so in expedite mode, we have to go for the early publication. So by paying the 2500 rupees extra, we can publish our application within a month. So after getting our application published, the patent office examine it, and by giving extra 4000 rupees, the patent office release the FER within 3 months. So by paying 6500 rupees more, we can expedite our patent examination, and the whole process is completing in 1 year or in maximum in 2 years. So the basic difference between research paper and patents are the both should be novel, non-obviousness is required, and industrial applicability is required for research paper, not required for research paper, but these are mandatory for the patent. Both get published, and money consumption, patent is a money taking process. Business perspective, for business perspective, patent is important, and there we don't have any right on research paper, but we have right on the patents. So here are some examples related to the medical field of examples of patent related to medical fields. For example, medical device. This is the patent of Dr. Bala Murugan, and he will discuss in detail about this later on. So this invention is related to the artificial intraocular lens spotting device for fighting patient treatment therapeutic device. Secondly, detection device. This is the artificial intelligence based portable dermoscope, and filed by the Punjab University, and radio pharmaceutical formulations can also be patented. So, corticotropin releasing hormone peptide for positron emitting tomography imaging in Cushing syndrome. Pharmaceutical formulations can be patented, for example, etodolac topical vascular composition, method of preparation for pain associated inflammatory disease and disorders. So these are the different form of patents then that can be filed from the medical field. We can protect a new formulation, a new device, any technology, any detection device, medical device can be protected. Now, if you have any query, we can discuss it.
You'll need to come here and ask. I think the mic, she won't be able to hear. So no, the mic is working. I didn't repeat the question. Well, you can give it to the other.
Thank you, Dr. Kavitha, for enlightening us with the process of patenting. I'll repeat, sir. It will pick up.
Nobody has questions.
Hello, madam. Good afternoon, and thank you very much for the excellent presentation. I just have one
Thank you,
small
sir.
query. You said that it may take up to 4 years if you go by the usual channels. It may take up to 4 years for the patent to be granted. Could you let us know what exactly happens during those 4 years? What is the behind the
Uh,
scenes things which
uh,
actually happen in the patent office once we file the patent that it's going to take 4 years?
So usually it takes 3 to 4 years. Actually, when the patent office examine our application only after the publication, and if we do not file any early publication request, then then our application is published after 18 months from the date of our filing. So 1.5 years are just consumed in just the publication of our work, and after publication, the patent office examine our application, and it takes another half to 1 year. So after the examination, they give us a first examination report, and we submit the FER response within 6 months. So this and after submitting the examination report, the controller gave us hearing approximately after 3 to 6 months. So the whole process takes approximately 3 to 4 years. So when we go with the expedite mode, so they give the priority to our application, and we can fasten the whole process. Firstly, we actually save the 18 months of publication. Just after filing the complete specification, we file the early publication, and within month they published our examination, and within 3 months they give us FER, and within they give us 6 months, but if we file the response within 1 or 2 months, then we can complete the whole process very fastly.
Thank you.
Okay.
Good afternoon, ma'am. Thank you for the presentation.
Thank you,
I
sir.
want to ask that I created a own agar gradient method to determine the MIC of antibiotics, and one is a commercial method that is available that cannot be replicated in the lab. And what I made that can be replicated in the lab, and the individual labs can make their own in-house e-test. I have already published it. I just want to ask whether that method can be patented or not, because that is a different technique, and what the commercially available is a different technique.
Okay. So you have already published your work. So there are very big. This is already in public domain. So now you cannot patent it actually. But there is another way. If you have revealed all the technology in your paper, then it is not patentable now. But if you have not revealed everything in your paper, you have just discussed about the results, but not about the technology, then you can go for the patent. But firstly, you have to you have to see all the matters that what you have already discussed. But if everything is disclosed, everything is revealed in your paper, then it's not good to go with the patent.
What is the reason for that, madam? Because the paper also has been published by him only. He is the person who has
Yes.
written. So why can't he patent it after publication?
Because sir, according to Indian Patent Act, your work should be novel. Your work should not be known anywhere worldwide. So according to Act, sir, in some countries, in US and other countries, they give us provision that even after publication within year we can file the patent. But in India, we don't have such provision. But if you want to go with Australian patent or American patent. So after publishing your work, you can go within 1 year, but their limit is within 1 year.
I have a doubt. Actually, my product was patent done in India, and it is limited to only Indian jurisdiction.
Sorry, sir, your voice is, sir, there is some disturbance. I can't hear clearly, please.
I have done patent in India,
Okay.
and it is actually limited to only Indian jurisdiction. And
Yes.
what if, and I have not applied patent in other countries, for example, US. So what if a company from US wanted to commercialize this package? So can they do it, commercialize this one without our permission?
Without permission, no country, no company can sell, import or export or use your product in India without your permission. But in another countries, they can do it, but they cannot get patent in that country. But they can sell your product without your permission in USA if you don't file any patent in USA. But they cannot get the patent in USA because it's already in public domain or at your name.
How long will it take in other countries, for example, US, for filing the patent?
Yes, for patent in other countries, so there are two routes. Firstly is the PCT, Patent Corporation Treaty, and second is the individual. We can approach the individual country. If you protect your work in specifically in America or Australia, then you have to file your application in the America or any other country, and you have to follow the whole process of patenting according to that country. And there is another mode, PCT patent, in which we file a single application and they give us 31 to 32 months, and you can approach the they give you report of your work, that your work is patentable or not in other countries, how much your work is novel according to the worldwide. And if you think that your work is good, then you can with the help of the PCT, you can go with in the national phase. Then you have to file again individually, in America, in Canada, in Australia, and there are 158 countries of PCT. But this is the all money consuming method, so it's good if you have any financial partner.
Ma'am, is there any ongoing fee that an institution should pay if there is a patent filed by the institution?
Ma'am, ongoing fees means
Every year should we have some fee?
Ma'am, there are fees. There are firstly patent filing fees. These are all government fees. Patent filing fees, this is 1,600 rupees in case of individual or for educational institute. And secondly, if there is an examination fees, and this is 4,000 rupees. These are two fees, government fees that the applicant has to be paid. And if you go for the expedite made, then more than 2,500 extra for the publication and 4,000 for the expedite examination. So these are the government fees, and with that there are professional charges, and all the expenses are usually bear by the applicant, and all the rights of a patent belongs to the applicant.
So how much will be the total amount which is spent by the applicant if one goes through the expedited and through a professional agent, madam? Approximate cost?
Sir, it's a government fees. I already told you. The professional fees, sir, it's all depend upon person to person, according professional to professional. So if you want, we will give you quotations of our fees, and if you have any other institute, our IPR firm, you can discuss with them their fees. I can tell you only about the government fees here.
Excuse me, ma'am.
Yes, sir.
Madam, is it possible for a government employee to actually file individually? Because personally, there is a legal provision, I think.
Sir,
What is the-
actually, this all depends upon your IPR policy. If your institute has matlab IPR policy, and according to that, you cannot file a patent at your own name as an applicant, then you have to file the patent only at the name of the institute. But if your institute don't have such policy, then you can go the filing at your name. So it's depend upon it's not the matter of the government employee or not. It's depend upon your institute policy, IPR policy.
Good afternoon, ma'am.
Good afternoon.
If you want to modify any equipment which is already available in general public, should we take permission of the respective company before we start modifying the equipment?
Sir, actually, so please repeat the question because voice is not clear. Please.
Sorry, ma'am. I just
It's
wanted to
fine.
know if you want to modify an equipment which is already present in the public domain, and you think you can increase its efficiency. So should we ask prior permission, because there might be similar equipments? So if you take one or two companies and then modify it and then claim that the device is superior to the previous existing one, so will we have to take permission from one company or all the companies before we start developing it?
So usually it is not mandatory to take the permission from the company if you have, because in the case of patent, invention means the advancement, technical advancement. So if you do any technical advancement of any existing prior art, then it is not mandatory to take the permission from that company. You can go on your own basis. So there is no need to take the permission from companies. If you are using your product as it's, you are using products as it's without any modifications, without any changes, and if your product is not patentable, if you just do simple arrangement or rearrangement or just simple modification, so you have to take permission from that company. But if you developed a new product, a new inventiveness in new in the form of patent text, then you can go directly without taking any permission from company.
Okay, ma'am. Just a follow-up question, madam. Like, is there like, if you're say modifying, how much modification will be accepted into patents and how much like
So,
what difference?
this
How do you calculate the difference since it is more subjective?
yes, sir. So this modification should have technical advancement. Technical advancement means that there is some particular problem with the existing one. There is a device and it has some lacunae, it has some problem, and you overcome this problem. So your product is considered as patentable. And
Okay, but is there any? But is there
and
anything called a subjectiveness, madam? Like, if one feels it is, say, like there is an improvement, and others might feel that it's not that improved. So, will patent office look at the subjectiveness of the modification?
So usually they judge according to the cited documents in the FPR. In the FPR, they usually give us limited number of documents. They do not give us the all documents, 100 or 200 documents. They give us 5, 6 or 2, 3 documents. So we have to give them reply in the light or in the comparison of that documents. So if our work is considered as the modified or having some advancement compared to these documents, then we can say that our work is novel, our work is patentable. So there is no clear-cut criteria that this much of inventiveness or this much of advancement is required. So there is no sharp line or no clear-cut criteria. We have to judge it according to the given documents.
Okay, ma'am. Thank you.
Okay.
Any other questions? There's another question, ma'am. During
Yes,
what stage of the process of patenting can we publish it?
Sir, ma'am, after filing your patent, you can publish it. Even for example, I file your patent at 4 o'clock, then at 5 p.m. you can publish your work.
Any other questions?
Ma'am, I just want to know, is this patent processing is all online process, or individual like applicant visits, multiple visits are required to the patent office?
Ma'am, online process and offline both processes are available for patent filing, but we usually go with the online mode because here we do not no need to visit the patent office.
So
All
we
the
will
things,
never
all
be
hearings.
required.
No,
So ma'am,
never,
we will
never.
never require. Oh.
No, ma'am, never. It is not required to visit the patent office. All the even hearings can be attended online.
So suppose if somebody has created an equipment that is not physically seen by them, only the photograph and those things are sufficient, or they will want to physically see that?
Sir, no, sir, it is not mandatory that you have prepared the instrument. If you have theoretical, it is if you are theoretical, you have prepared, you have pictures, then you can go with the patenting. No physical equipment is required.
Is copyright a stronger protection or patent is a strong protection?
Sir, copyright and patent are different forms of IPR. If you have an invention that it is protected through the patent, but you have some literary, dramatic, artistic work, then it is protected through the copyright. So these are completely different things. You cannot protect your book, your literature with the patents, and you cannot protect the invention through the copyrights.
Thank you, ma'am. It was a very interesting and a very informative session from your end. And I thank all the faculty for their active participation.